This is a lecture for my professional responsibility class. We're starting our unit on advertising and solicitation by lawyers. And before we get to the rules, I have a few background points or introductory issues that I need to kind of flag for my students that you need to keep in mind as we look at the rules. So let's take a look at some slides I've prepared for you. This is an introduction to advertising and solicitation, which is going to be Model Rules 7.1, 7.2, 7.3, and 7.6. The first point I want to make is that the earliest legal ethics codes from the beginning of the 20th century banned all lawyer advertising. So this was kind of the default rule nationwide. As modern advertising, mass media advertising sort of became a thing at the end of the 1800s, lawyers started to advertise, and the ABA and state bars responded by saying lawyers shouldn't advertise at all. So they didn't want lawyers, especially advertising their fees. And they would justify this by saying things like it will demean the legal profession, or we're afraid that lawyers, unethical lawyers, will take advantage of clients and so forth. So we come into the 20th century with a ban on lawyer advertising that lasts for decades. And if you are in a state with a state bar that's very traditional, this is still the kind of the old school thinking, is that real lawyers don't advertise. I know this may be a foreign concept. Most of us grew up in a world where there are lawyer ads, TV commercials, print ads, billboards everywhere, but that's a rather newer phenomenon that was sort of forced by the US Supreme Court. Next, I want you to keep in mind that of all of the ABA's model rules of professional conduct, advertising rules have the most variation between states. So there's a lot of other rules where a lot of the states are pretty consistent or have mostly adopted the ABA's rules. Advertising is the area where we get the most variation, and sometimes extreme variation, state to state. So as a lawyer, you need to watch out for this. And this is a concern for the ABA as well, that what may be permissible in your home state for running ads, if you decide to open an office in another state where you're admitted, they may have very different rules about advertising. Also, the Texas rules are quite extensive, much more detailed and honestly burdensome than the ABA's model rules. And they are in the process, as I'm recording this video, that earlier this year, they proposed a major revision to the rules, but even that is not going to look exactly like the model rules. So when you're in practice, if you're going to practice in Texas, look up the rules about advertising when you have to make these decisions. Okay, the next thing you need to know is that the ABA itself overhauled the advertising rules in 2018, in late July, early August of 2018, and they eliminated the old rule 7.4 and 7.5 and moved some of the provisions from those rules into the comments of 7.1, 7.2, and 7.3. This means that if you are using the second edition of my Glanning Guide, which went to print right before these changes were made, it has some sections that are numbered incorrectly and a couple of questions that are no longer substantively accurate. And so for my students, if you're using the second edition, there's an errata page or a corrections document that you really need to reference when you get to the advertising section. And also, if you are taking a course where there's a casebook, or you're using other types of study aids, or even some of the Barbary, Themis, and Kaplan prep materials for the MPRE, watch out, because a lot of the materials that are out there were done before the ABA changed the rules, and they could have some errors. The most significant substantive change to the rules is that the ABA eliminated the requirement that you print advertising material on unsolicited letter mailings. So they used to have this old rule that was the advertising material rule, or sometimes called the envelope rule, that if you were sending unsolicited letters to prospective clients offering to represent them, that you had to say advertising material on the outside of the envelope. And the ABA has done away with that rule. Whether your local state has is a different question, but the ABA has, and so make sure you know that for the MPRE. The next point is there have been, as you might expect, many cases with lawyers bringing constitutional challenges to their state's advertising restrictions. And I'm going to now, in the rest of this video, tell you about a few of the most significant ones that have changed and shaped the rules as we have them now. But keep in mind, there's a large kind of body of law that's the First Amendment and its relevance to lawyer advertising rules, and it's sort of ever changing. That being said, the first big case or leading case in this area is from 1977, and it's Bates versus the State Bar of Arizona. Now, I'm going to talk about 4 cases here. You don't need to learn the names of these cases for the MPRE. They will not ask you about case names, nor will my final exam, but they could give you the facts from a case and ask you then sort of like what would you expect the holding to be and why, or something like that. So I'm going to just tell you about the most important cases in this area that reshaped the rules. In Bates, this was the court held that the First Amendment protects truthful newspaper advertising by lawyers regarding fees and services. And remember, coming into this up until the 70s, really, most states prohibited lawyer advertising or severely restricted it. Now, this was 2 former legal aid lawyers who had worked for a clinic that provided free legal services for indigent clients. And they realized that there's a lot of people who are too poor to afford a lawyer, but they're not indigent enough to qualify for a legal aid free lawyer. So these 2 former legal aid lawyers opened an office to provide discount or low cost legal services for the poor. And they wanted to provide routine legal services for moderate income persons, the working poor, who could not qualify for government aid, but who also would be priced out of hiring most lawyers. And they went ahead and ran a newspaper advertisement with their fees for standard services, which was a violation of Arizona law and ethics rules. And the state bar imposed a token discipline on them, a 1-week license suspension, just to make a point. Now, I want to say something about this case. These are legal aid lawyers. They decided it was the principle of the thing, and they took the case all the way to the US Supreme Court. It's a little bit of a mystery to me why the state of Arizona bothered fighting it for that long when this was only something worth disciplining lawyers for 1 week. And the Supreme Court said that the prohibitions on lawyer advertising were too broad, right? And they violated the First Amendment. And it is okay to discipline lawyers for untruthful message advertising, false advertising. That's okay, and you can be really strict about it, and you can require a number of things in the ads themselves, like the lawyer's name and contact information and so forth, but you can't have a complete ban on lawyers advertising or lawyers advertising their fees. The next year, we get a pair of cases. And if the legal aid lawyers were sort of the ultimate sympathetic petitioners before the court, right? These are people that just want to help people and offer discount legal services for those who can't afford them and provide access to justice. So the Supreme Court was disposed to like those lawyers. O'Reilly, who was in Ohio being disciplined by the Ohio State Bar, is sort of the stereotypical sleazy lawyer who's hard to feel sorry for. And in this case and the companion case that came out the same year, the Supreme Court drew a very important distinction between advertising and actual person-to-person solicitation. So direct solicitation of an individual by the lawyer, which they said it is actually okay for states to restrict. So advertising, we have more First Amendment protection for than directly confronting a person and offering to represent them. Now, here's what happened. O'Reilly was a lawyer, and he listened to the police scanner or the news and realized that there had been a traffic accident involving a couple of teenage girls in his town. and he went to and visited one of these teenagers who was 16 or 17 in her hospital room when no one else was there, and talked her into hiring him to represent her regarding the accident. Unbeknownst to her, O'Reilly was wearing a large trench coat style overcoat with a cassette deck strapped to his body underneath it and was recording the conversation. O'Reilly then went to the other passenger in the car, who was another teenager, who was also injured but was at home. She wasn't hospitalized. And the parents answered the door and said, "We have a family lawyer. We don't want to hire you." He tried to force them and said, "You have to hire me because her other passenger also hired me. And the two of you, if I represent one of you, I have to represent both of you." Now, you've studied the conflicts rules. You know that this is like opposite day. The exact opposite is true. You should be cautious about representing co-plaintiffs. He was so desperate for another client that he presented it like they were obligated to hire him, and the parents told him to get lost. They then, because they were offended, went and contacted the friend who was in the hospital, and said that she should fire O'Reilly and not use him, and that their family lawyer would represent her. And then O'Reilly tried to say, "You can't fire me because an oral contract is binding and you agreed to hire me and I recorded the conversation secretly." And this is the character that comes before the Supreme Court, and the Supreme Court said, "You can go ahead and discipline people like this." That same year, though, we get another type of public interest lawyer. This is an ACLU lawyer, and this is the In re Primus case. So please note that in O'Reilly, we drew a big line between advertising and solicitation, and that is now built into the structure of the model rules. You're going to see very different, like completely separate rules for that covering advertising versus solicitation, and also a general rule that says you're not allowed to lie in either circumstance. So an ACLU lawyer spoke in person to a group of women and then contacted others by letter offering free legal services. So he wasn't looking for a fee at all. And the bottom line is the Supreme Court said that is okay and does not and has more First Amendment protection than O'Reilly did, who was offering to represent someone for a fee. So the court draws a line even within solicitation between paying clients and pro bono work or free representation or public interest work. This took place in South Carolina. South Carolina at the time had a policy of sterilizing certain women as a condition of receiving welfare so that they wouldn't have more children while they were on welfare. And if that's shocking to you, I want you to notice the date of this case. This was happening as recently as the 1970s, that states had as a condition of receiving welfare payments that you would be sterilized. Primus sent some letters to women who had been sterilized, offering them the legal assistance of the American Civil Liberties Union, the ACLU. And then South Carolina Supreme Court Disciplinary Board reprimanded Primus for violating the South Carolina bar rules against soliciting business, and he appealed to the US Supreme Court. And again, here we have a sympathetic petitioner. The Supreme Court sides with the ACLU lawyer in this case. So please note that these three cases I've just talked about lay down the structural framework for the modern rules about advertising, including the rules that we have after the 2018 amendments of drawing a distinction between advertising, which you definitely has a lot of First Amendment protections, versus in-person solicitation like O'Reilly did, and then they're going to kind of carve out an exception for in-person solicitation where you're offering to represent people for free. The last point I want to bring up is a case that from 1995, so kind of fast forward, called Florida Bar versus Went For It, Inc. And before I even describe this, I have to tell you there's a number of cases on this type of point, but this is one of the main ones from the US Supreme Court. There's a number of circuit court cases and state Supreme Court cases. And these are about waiting periods before you contact someone after an accident. And Florida had a 30-day ban on direct mail like solicitations for accident victims. And this company was contacting people, offering to provide legal services for them after a big accident that had received a lot of, so there was a highly publicized catastrophe. And so people got the list of victims and sent letters to their families offering to represent them. And the Supreme Court said, and they, by the way, they have asked about this on recent MPRE tests, is it okay for a state to have a cooling period during which lawyers are not allowed to contact prospective clients after an accident? And currently the answer is yes. Please note this is a 5-4 decision, so it could change at any time, as the personnel on the court has definitely changed since 1995. So the court noted in this case that lawyers can, of course, still advertise during this period. So people are not like immune from knowing that there's lawyers out there who want to represent them. And even if there's let's say it's hurricane damage, you can put up billboards right away after a big storm or wildfires or some other type of catastrophe or natural disaster or a plane crash, and saying, if you are injured in this, we want to talk to you, and you will have a lot of freedom to advertise. But if you're getting lists of victims and sending letters directly to their home, then you do need to pay attention to your state's waiting periods. And a number of states have these, not everywhere. This is not part of the model rules, but it is part of our body of law right now about lawyer advertising. And this is a fair game question. So modest waiting periods are okay. What we don't have from the Supreme Court is how long is too long. They have hinted that that really long periods, like 6 months, might be too long and might actually be unconstitutional. We can't ban lawyers from like ever contacting accident victims, but 30 days is a pretty modest restriction, the court said, and so they didn't see what the big problem was. Okay, that concludes our introductory lecture about advertising and solicitation. And after this, we'll move on to videos about the rules themselves.